Welcome back to The Explainer. Today, we're jumping right into everything you need to know about the preamble. For a lot of people, the Constitution might just seem like a dry, static text, a dusty rulebook written decades ago. But today, we're going to treat it exactly like the living, breathing puzzle that it is. We're going to see firsthand how just a few opening words sparked some of the most dramatic, high-stakes legal battles in history.
Okay, let's dive into this with a really powerful thought from Justice S. Ratnavel Pandian. He said, "The inevitable truth is that law is not static and immutable, but ever increasingly dynamic and grows with the ongoing passage of time." If we look at the law organically like that, we can see how the Supreme Court has actively shaped and revitalized these core constitutional values from 1950 right up to this very moment. Keeping that reverent tone for the court's historical role in mind, let's look at how our legal landscape has actually grown.
Here's our roadmap for today. We'll be decoding the preamble, asking, is it actually the Constitution? Looking at the power to amend, unpacking the basic structure doctrine, and finally, balancing rights and directives. Let's get right to it.
Section 1. Decoding the Preamble, the absolute heart of the Constitution. Now, what's really fascinating here is the sheer weight these specific words carry. On one side, we have the identity of the nation as it was established in 1949, sovereign, socialist, secular, democratic, republic. And on the other, we have the profound promises made to its citizens: justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and fraternity, assuring the dignity of the individual. These aren't just fancy, monumental words. They literally encapsulate the entire soul of the document. But as beautiful as this text is, it led to a massive legal dilemma. And that dilemma is this: what is the actual on-the-ground legal significance of the preamble? Think about it for a second. Is it just a nice introductory preface? Is it a legally binding part of the Constitution? And crucially, can a law passed by the government be thrown out, declared ultra-virus, solely based on these grand opening words? This wasn't some abstract academic debate. This tension literally shaped decades of jurisprudence.
Which brings us to Section 2. Is it the Constitution? A massive legal dilemma. Let's wind the clock back to the Rue Barabari case. In this early decision, the Supreme Court took a very strict, narrow view. They flat out ruled that the preamble is not a part of the Constitution, and because of that specific reasoning, they declared it holds absolutely no substantive power on its own. Imagine that. The very soul of the document was treated almost like a foreword in a novel. Great to read, but legally, not binding. But as we established earlier, the law is dynamic, and this narrow interpretation was about to be seriously challenged.
Section 3. The power to amend. Examining parliamentary power. Enter the Goloknath case of 1967. Let's look at the human element here, because that's where law always starts. You've got the Goloknath family, right? They own 500 acres of land, but the government introduces a Land Tenure Act that heavily restricts ownership. Suddenly, out of 500 acres, this family is only allowed to keep roughly 30. The rest is to be taken by the state. Obviously, the family challenged the act, but in doing so, they didn't just fight for their property. They sparked an absolute constitutional crisis. The fundamental question became, does Parliament have the unlimited power to amend the Constitution? Can they literally just amend away our fundamental rights?
And this brilliantly illustrates the ultimate clash. Think of it like a heavyweight bout. In one corner, you have Article 368, which gives Parliament the power to amend the Constitution. In the other corner, you have Article 13, which explicitly says that any laws inconsistent with fundamental rights are void. So, does the amendment power override fundamental rights, or do fundamental rights limit the amendment power? Well, in Goloknath, the Supreme Court ruled that Parliament does not have the power to amend Part 3 of the Constitution to take away fundamental rights. But, as you can probably guess, the tug-of-war didn't stop there.
Section 4. The basic structure doctrine. Redefining our legal bedrock.
Let's move forward and see how this all builds organically over two defining decades. Look at this progression. We start with Rue Barabari in 1960, hit that massive clash in Goloknath in 67, and arrive at the absolute turning point, Keshavananda Bharati in 1973. That's followed rapidly by the Indra Narogadi case in 75 and Minerva Mills in 1980. This timeline maps the exact journey of our constitutional bedrock. Let's zoom right in on that pivotal 1973 moment.
Keshavananda Bharati versus State of Kerala. This is arguably the most celebrated case in the history of Indian constitutional law. What's absolutely wild here is that Keshavananda Bharati was actually a Hindu monk just trying to protect his monastery's property, and he accidentally ended up saving Indian democracy. The issue is so monumentally important, it required a historic 13-judge bench to settle the debate. The outcome was a razor-thin 7-6 majority. The court ruled, okay, Parliament absolutely can amend the whole Constitution, including fundamental rights, but they drew a massive, hard line in the sand. They said that while Parliament can amend the text, the basic structure of the Constitution cannot be touched or abrogated.
But let's bring it back to everything you need to know about the preamble. Look at this stark contrast. Back in 1960, Re-Brubari said the preamble is not part of the Constitution. Fast forward 13 dynamic years, and Keshavananda Bharati completely overrules that. The Supreme Court decisively declared that the preamble is a part of the Constitution. It went from being a mere preface to the actual guiding light of the entire document.
So the crucial point for us is grasping this definition crystal clearly. The doctrine of basic structure is the principle that Parliament's amending power inherently has limits. It cannot abrogate or destroy the fundamental features of the Constitution. Think of it like this. Parliament can totally remodel the house, sure, but they cannot destroy the foundation. And importantly, the court smartly left it open, saying what actually constitutes this basic structure would be decided on a case-by-case basis.
Well, they certainly didn't have to wait long to test it out. Just 2 years later, we get the Indira Gandhi case, often called the election case. Quick context, the Allahabad High Court had just invalidated Indira Gandhi's election due to corrupt practices. While the appeal is happening in the Supreme Court, Parliament rapidly passes the 39th Amendment, throwing in Article 329A. This basically said that judicial review cannot be done in matters related to elections. The Supreme Court immediately whipped out their new doctrine. They struck down Article 329A, declaring that democracy, free and fair elections, rule of law, and judicial review are all part of the basic structure. Parliament cannot amend them away. And notice how these protected features, democracy, rule of law, are direct descendants of the promises made right there in the preamble.
Section 5. Balancing Rights and Directives.
The ultimate test came in 1980 with the Minerva Mills case. This case directly challenged the highly controversial 42nd Amendment, which attempted to expressly give unlimited amendment power to Parliament and completely exclude the courts from reviewing constitutional amendments. The tension here is palpable, right? Parliament was essentially yelling, "We are supreme and the courts cannot question our amendments."
Well, the Supreme Court pushed back. By a 4-1 majority, they struck down those clauses of the 42nd Amendment. They delivered an incredibly powerful conclusion. Parliament's power to make constitutional amendments is limited. And get this, that limitation is itself a basic feature of the Constitution. This judgment makes it absolutely crystal clear. The Constitution is supreme, not the Parliament.
But Minerva Mills did something else incredibly important regarding the actual structure of the document itself. We often think of Part 3, our fundamental rights, being in direct conflict with Part 4, the directive principles of state policy, which are the broad social and economic goals of the state. For years, people wondered, when these two collide, which one actually wins?
Here's where the preamble stepped up to be the ultimate bridge. The Supreme Court declared, there is no case of superiority between Part 3 or Part 4. Both are complementary to each other. And how did they establish that harmony? By being guided by the ideals of justice, liberty, equality, and fraternity laid out right there in the preamble. It became the definitive lens through which the entire Constitution must be read.
So what an incredible journey we've traced today. From being dismissed as just a mere preface in 1960 to becoming the recognized soul of the Constitution and the very bedrock of the basic structure doctrine. It proves that the law truly is organic and dynamic. But it leaves us with a really provocative thought to wrap up today's explainer. As our society continues to evolve and knowing that the Constitution, and not Parliament, is ultimately supreme, which foundational pillar of the basic structure do you think is going to be tested next?